Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property-related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
Picture this. It is 7 a.m., you haven't even had your coffee yet, and you are staring at an ad for jalapeno ranch flavored soda from Olipop.
Oh, that sounds absolutely vile.
Right. But for 5 terrifying seconds, you completely fall for it. You look at this perfectly rendered, super sleek aluminum can of, garlic-infused carbonation, and you just think, wow, the beverage industry has finally lost its mind.
Yeah, they've just completely jumped the shark.
Exactly. And then, you check the calendar, and it's April 1st.
We have all been there. I mean, that momentary suspension of disbelief. The internet has essentially turned into this massive gauntlet of hyper-realistic corporate pranks every single spring.
And the execution is getting flawless.
Yeah.
Think about the fake collaboration between Tic Tac and Dr. Pepper.
Oh, the little mints.
Yes. They released images of these little mints, meticulously designed to look exactly like tiny miniature soda cans.
Yeah.
You see it, you immediately want to buy it, and then the realization washes over you that you have just been totally played.
It's a very specific kind of internet betrayal.
It really is. Okay, let's unpack this. Because today we are taking a deep dive into something you probably never think about when you're laughing at these viral posts.
Yeah, the stuff behind the curtain.
Right. What you don't see behind that heavily photoshopped can of jalapeno soda is a massive, highly stressed legal team. So we are exploring the invisible, super complex legal guardrails that keep these corporate jokes from turning into catastrophic courtroom disasters.
It is an incredibly high-stakes environment, completely hidden behind a facade of harmless fun. Because April 1st is universally treated as a day for viral marketing campaigns and wild product announcements.
Everyone wants to be the funniest brand on the timeline.
Exactly. But the foundational laws of commerce, specifically intellectual property or IP, they do not take a holiday just because a brand decides to be funny for a day.
The lawyers are still on the clock.
Very much on the clock. Trademarks, copyrights, patents, they are all operating at full force. And navigating them requires a level of precision that, honestly, most consumers are completely blind to.
Which feels almost contradictory, doesn't it?
Yeah.
Like a joke, just by its nature, is supposed to be kind of reckless and subversive.
Yeah, spontaneous.
Right. The idea that a meme has to pass a rigorous legal review before it gets posted is just wild to me.
Well, when you break it down, every great prank usually involves borrowing someone else's authority or, their identity to make the punchline land.
Oh.
And the moment a brand borrows another brand's identity, we hit our first massive barrier, which is trademark law.
Let's get into that, because that seems like a total minefield.
Oh, it's a dangerous game. Let's look at the mechanics of why. Fundamentally, a trademark is an identifier of source. It's the brand name, the logo, the distinct color scheme.
Like the Nike swoosh.
Exactly. Its entire legal existence relies on guaranteeing to the consumer that when they interact with a product, they know unequivocally who produced it.
So it basically acts as a shield, right?
Yeah.
It protects the brand's reputation from imposters.
A shield and a highly aggressive weapon. Companies don't just use trademarks to protect consumers. They use them to actively shut down unauthorized associations.
And on April Fool's Day, companies love to play with those exact associations.
Oh, they do. They manufacture fake collaborations to leverage another brand's cultural cachet all the time.
Like, think about the absolute chaos. If a company put out a press release announcing a prank product called, Nike-flavored coffee.
Or a massive coffee chain suddenly releasing Starbucks running cues.
That scenario has to be a heart attack for an IP attorney.
It's a total nightmare.
Because you are hijacking an identity that just isn't yours. It reminds me of someone wearing a highly realistic security guard's uniform to a crowded concert, just as a prank.
Oh, that's a really good way to look at it.
Right, like you bought it at a costume shop, you aren't actually working, and maybe you and your friends think it's hilarious. But the venue owner is going to have a massive problem with you being there.
Because of the unearned transfer of trust.
Exactly. You are projecting an authority that causes genuine confusion for everyone else in that building.
That captures the core mechanism perfectly. Because in trademark law, the ultimate test for infringement revolves around that exact concept, the likelihood of consumer confusion.
So it's all about whether people actually buy the bit.
Essentially, yes. If a brand puts out a joke like Nike-flavored coffee, and people scrolling through their feed actually believe Nike officially sponsored this bizarre beverage, well, Nike's brand identity is actively being misrepresented.
And they could just drop the hammer.
They have the absolute legal right to step in and shut it down. What's fascinating here is how broad the legal interpretation of confusion can actually be.
Wait, how broad are we talking?
Well, it isn't just about someone accidentally buying the wrong product at the store. It includes this thing called initial interest confusion.
Initial interest confusion.
Yeah, where a brand uses another company's trademark just to capture a consumer's attention, even if the consumer figures out the joke before any money actually changes hands.
Wait, I have to push back on this. Because if I scroll past jalapeno ranch soda on April 1st, I know it's a joke. I mean, any rational person knows it's a joke.
You'd think so, right?
Yeah. How can a judge look at the calendar, look at the absolute absurdity of the product, and say, yes, consumers are genuinely confused by this? Doesn't the context of April Fool's Day offer some kind of built-in legal protection?
See, you are assuming two things there that the law fundamentally rejects.
Okay, lay it on me.
First, you are assuming every consumer has a high level of media literacy. Courts often evaluate trademark confusion from the perspective of the casual, less informed consumer.
The person who just glances at their phone.
Right. Sometimes it's even informally referred to in legal circles as the moron in a hurry standard.
Wait, really? The moron in a hurry?
Yes, that is a real phrase used in case law. You cannot assume everyone is in on the joke.
Okay, fair enough. I mean, some people will believe literally anything they read online. We've all got that one relative on Facebook.
Exactly. But second, and honestly more importantly in the digital age, you are assuming the joke stays tethered to the context of April 1st.
Oh, because of how things get shared.
Right. Social media platforms are entirely algorithmic. A brand posts the joke on April 1st. It gets shared, screenshotted, cropped, and reposted.
And the date gets lost.
Suddenly, it is April 14th, the date is totally stripped from the image, and 1 million people are looking at an out-of-context screenshot of Starbucks running shoes.
Wow.
The calendar defense completely evaporates because the internet decoupled the joke from the holiday.
Oh, wow. I never even considered the algorithmic delay. Once it's screenshotted, it just lives forever without the original caption.
It takes on a life of its own.
So these marketing teams, they have to engineer the image itself to be obviously fake, no matter when or where it pops up on the internet.
Exactly. They have to inject just enough absolute absurdity into the visual design to ensure a judge would agree that no reasonable person, even an uninformed one looking at it 2 weeks later, would think it's a real, authorized collaboration.
That is a wildly fine line to walk.
It really is.
So, okay, avoiding that brand confusion saves you from a trademark lawsuit. But let's say the brand nails that delicate balance. The logo is obviously a joke. The target is totally clear.
They've cleared the first hurdle.
Right. Now they actually have to execute the campaign. The brand name is safe, but the actual creation of the viral ad opens up a completely different legal trap, doesn't it?
Yes, it absolutely does.
Which brings us to the mechanics of copyright law.
This is where the actual production of the prank becomes incredibly precarious, because modern corporate pranks, they aren't just text posts anymore.
No, they're like mini-movies.
Exactly. There are high-budget productions relying on slick videos, custom graphics, and trending meme formats. And all of those creative elements, the underlying assets, they are protected by copyright the exact moment they are created.
And the temptation for marketing teams has to be to just grab whatever is currently going viral to make their joke land harder.
Oh, absolutely. It's the fastest way to get engagement.
Like taking a song that's currently #1 on the charts and just dubbing it over their fake product announcement.
Which is incredibly risky. Using someone else's copyrighted song to boost your corporate joke is, well, it's like borrowing your neighbor's expensive sports car to make a funny YouTube video without asking them.
Even if you bring it back with a full tank of gas.
Exactly. It doesn't matter if the video is hilarious, and it doesn't even matter if you didn't directly monetize the video. You still stole the car to make it. Copyright law grants the creator exclusive rights to reproduce and display their work, period.
See, I feel like people scream fair use online like it's a magic spell that just wards off lawyers. Like, isn't there a parody loophole for this stuff?
That's what everyone thinks.
Yeah, if the whole campaign is obviously a joke, doesn't that automatically shield the brand from copyright infringement?
This raises an important question because fair use is probably the most widely misunderstood legal doctrine on the entire internet.
People just put no copyright intended in the bio, and think they're safe.
Right, which does literally nothing legally. People assume parody is a blanket immunity, but the legal reality is entirely different. Courts draw a very sharp line between a parody and a satire.
Wait, what is the mechanistic difference there? Because to a normal person, those are just synonyms.
In an English class, maybe. But in a legal context, they are worlds apart. A true parody needs to use the original copyrighted work to make fun of or comment on that specific work itself.
Oh, I see.
Think of a musician recording a spoof of a famous pop song to specifically mock the pop star's ridiculous lyrics. The law provides strong, fair use protection for that because you kind of have to use the original song to mock the original song.
Okay, that makes total sense. You can't really critique a painting without showing the painting.
Right. But satire uses the copyrighted work merely as a vehicle to make a broader point, or, in the case of our April Fool's brands, to sell a joke about their own product.
So they aren't commenting on the song at all.
Exactly. If a brand takes a popular copyrighted song just because it sounds cool, and they use it as the background track for their fake edible coffee cup commercial, they aren't parodying the song. The song is just a prop.
So if I use a famous pop song to make fun of the pop star, that might be fair use. But if I use that exact same song to make fun of my own brand of shoes, I'm just stealing the song.
Precisely. You are using someone else's property for your own commercial gain. And courts heavily weigh the commercial nature of the use against the infringer.
But the product is fake. How is it commercial gain if they aren't selling the shoe?
Because the marketing campaign itself is designed to boost the brand's profile. Getting 1 million views and raising brand awareness is a massive commercial benefit, even if the specific product in the video doesn't exist.
That entirely reframes how I look at these viral videos.
It changes the whole perspective, doesn't it?
It really paints a picture of like marketing departments sitting in these windowless conference rooms, arguing with their legal teams over exactly how many seconds of a generic royalty-free beat they can use.
Oh, those meetings definitely happen.
Because using the real trending audio is just too legally radioactive.
It is a calculated risk assessment down to the individual frame of a video. They are constantly asking, does this transform the original work enough? Does it serve as a market substitute for the original?
Okay, so let's push this scenario to its absolute limit.
Let's do it.
You have somehow navigated the brand identity minefield of trademark law.
Oh.
You didn't steal anyone's music or art, so you completely avoided the copyright trap.
The lawyers are happy.
The lawyers are thrilled. The joke goes live. It is a massive hit, millions of views.
Best case scenario.
Right. But then something terrifying happens. The public doesn't just laugh. They pull out their credit cards. They actually want to buy your fake product.
Ah, the classic backfire.
Yes. This moves us away from protecting logos and videos and drops us straight into the most surprising element of this whole ecosystem, which is patents.
This is where the legal theory meets hard engineering. Because a massive tradition on April 1st is the completely fake, hyper-innovative product launch.
Here's where it gets really interesting. Think about some of the legendary fake products brands have pitched over the years, like self-tying shoelaces for pets.
I would buy those in a heartbeat.
Right. Just imagine a sleek commercial showing a dog tapping its paw and the shoes mechanically zipping up. Or edible coffee cups.
Oh, the edible coffee cups were brilliant.
You finish your morning latte, and then you just eat the cup like a waffle cone.
They are engineered to sound delightfully absurd.
They are.
Yeah.
But the realization that blew my mind is that while these are imaginary props for a joke today, the underlying concepts behind them could actually be patentable inventions.
If they were actually real.
Yes. If they were real, they represent actual, highly valuable intellectual property.
If we connect this to the bigger picture, it reveals a fascinating dynamic. Because history has shown us repeatedly that products starting off as mere internet gags frequently evolve into tangible innovations.
It's basically the ultimate free market research. A company throws the most absurd idea against the wall as a prank. They intend for it to be a one-day gag. But the internet reaction is overwhelming. Millions of people share it. The comments are demanding a release date.
Wreck my money.
Right, take my money. And suddenly the R&D department looks at the 3D rendering and says, wait a minute, could we actually build the edible coffee cup?
It is a brilliant pivot. But that pivot triggers a massive largely invisible legal scramble.
Because they don't actually own the invention yet.
Well, because when a joke accidentally turns into a viable product roadmap, the company has to instantly shift from maximizing virality to aggressively locking down their new idea.
Okay, and the mechanism for doing that is filing for patents.
Exactly. But here's the critical flaw. The joke itself might have just destroyed their ability to get one.
Wait, how can the company's own joke hurt them?
It comes down to a foundational concept in patent law called prior art.
Prior art. Okay, explain that.
To be granted a patent, an invention must be completely novel. It cannot be known to the public before the patent application is filed.
Oh, no. Because they posted the hyper-detailed prank video.
Exactly. If a company's marketing team puts out a highly detailed 3D rendering of those self-tying pet shoes, and the joke video actively explains the theoretical mechanics of how the tiny motors would work to make the joke land.
Which they do to make it look real.
Right. They have effectively published a technical disclosure. That meme legally acts as prior art.
Even if it's fake.
Even if it's fake. If the engineering team goes to the patent office a month later and says, hey, we invented this, the patent examiner can literally look at the company's own viral tweet and say, no, you didn't. This was already publicly known. You disclosed it yourselves last month.
So the meme is legally interpreted as a blueprint in the eyes of the patent office, yes.
That is staggering. The marketing team could accidentally invalidate a multi-million-dollar patent just by making the joke too technically accurate.
It happens more than you'd think.
So how do they survive that? Do they have to file legal paperwork before they post the meme?
That is precisely what happens behind closed doors.
You're kidding. I'm not. If a company suspects their fake April Fool's product might actually be viable, or if, say, the engineering team was actually playing around with a real prototype to inspire the joke in the first place,
Which makes sense.
the legal team will quietly file what is called a provisional patent application on March 31st.
Just in case.
Just in case. A provisional application acts as a relatively cheap placeholder. It establishes an official filing date with the patent office before the joke ever goes live.
So it secures their place in line.
Exactly. Then they release the gag on April 1st. If the internet completely ignores it, they just let the provisional patent expire and they move on.
No harm, no foul.
Right. But if the internet goes crazy for it, they already have their priority date locked in, and they have a full year to file the actual expensive patent application to protect the mechanics they publicly joked about.
That is so incredibly sneaky but brilliant. Or, I guess, if they didn't explain how the edible coffee cup works in the video, they just locked down the recipe as a trade secret, right?
Yes, that's the alternative.
Like the formula for Coca-Cola. As long as the video just shows someone eating the cup, but doesn't actually list the ingredients on screen, the secret is still safe.
Exactly. Trade secret law becomes the backup parachute if they didn't file a patent, but managed to keep the actual engineering hidden during the prank.
Wow.
It just highlights how incredibly multi-layered the strategy has to be.
So what does this all mean? We started by talking about those specific relatable moments.
Yeah.
You're scrolling on your phone, you see something ridiculous like a garlic ranch soda, and you just laugh at the absurdity of the internet.
Just another day online.
Right. But peeling back the layers on this, it completely shatters the illusion of the careless corporate prank. Despite the playful, chaotic, anything-goes spirit that companies project on April Fool's Day, these campaigns are actually the result of militaristic planning.
They're heavily sanitized exercises in risk management. That is the ultimate takeaway here.
Which is kind of a buzzkill, but also fascinating.
Right. Whether it is navigating the likelihood of consumer confusion to avoid trademark dilution, or dodging the myth of the parody loophole to ensure they aren't committing copyright infringement, or quietly filing provisional patents just in case their fake product goes viral.
Intellectual property is the invisible scaffolding holding up the entire holiday.
It really is.
It really changes how you consume media. It's like learning how a magic trick works, only to realize the magician's secret is just a massive stack of highly scrutinized legal paperwork.
A very, very expensive stack of paperwork. Because behind every laugh-out-loud product announcement you see, there is a severely caffeinated marketing team.
Oh, absolutely.
And an incredibly anxious corporate lawyer meticulously ensuring the punchline doesn't end in a massive settlement.
It is fascinating, and it leaves me with one final thought, something for you to mull over the next time you're scrolling through your feed and you spot one of those elaborate gags.
Oh, I like where this is going.
If a massive brand posts a viral joke about an imaginary product, say those self-tying pet shoes, and they didn't file that provisional patent.
A fatal error.
Right. What happens if an opportunistic listener like you sees that joke, figures out the engineering in your garage, builds a working prototype, and files for a patent the very next morning?
The race to the patent office.
Exactly. The brand made the joke, but you built the reality. Who legally owns the punchline then? Keep that in mind the next time the calendar rolls over to April 1st and you find yourself staring into the timeline, trying to figure out what's real, what's a joke, and who exactly owns the right to make you laugh.